Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For our second stream this evening, we'll be covering the recent new indictments against Netflix relating to the movie Cuties. As I'm sure you will recall, there was a movie Cuties which involved some very, very young girls doing some very, very suggestive dancing, and the promotion material in particular was very, very suggestive, as many of us will recall. So Texas, or at least one person in Texas, has brought criminal charges against Netflix for obscenity, right? The First Amendment does not protect obscenity, right? It protects pornography, but doesn't protect obscenity, all right? So what we have to decide, among other things, is whether or not the movie or the promotional materials or some other aspect of what Netflix did qualifies, or can at least arguably qualify, into the standard of obscenity. All right, so in order to try to decide this, at least in part, we're going to review a motion that Netflix has filed in federal court to try to prevent the criminal charges from going forward. They're trying to prevent the office of the district attorney from proceeding with these charges on First Amendment grounds. So there's a whole bunch of exciting, interesting questions here, right? So you have a relation to an ongoing criminal proceeding. Obscenity is, in fact, illegal. It is not protected by the First Amendment. And so there might be a question as to whether or not this is obscenity, at least as in part factual questions. So there's all kinds of issues like, can the federal court intervene at this stage? I mean, this is all before like a fact finding. This is all before a trial, right? This is all before anything. Like, we're in the preliminary stages. So can the court interfere? Should the court interfere? Should they allow the thing? Should Texas handle this issue? Is this an issue even for federal courts at all at this stage, right? All kinds of fun questions. So we're going to review all this and get started with this. So let's do that. All right, so we're in the United States District Court for the Eastern District of Texas in Lufkin. All right, we're in federal court to try to bring a civil action to stop a criminal. So we're in federal court on a civil action to try to stop a criminal action in state court. All kinds of interesting separation of powers problems lurk their head, right? This is all kinds of interesting stuff here. Let me make the font work. All right, let's go ahead and get started with reading this. Netflix brings this complaint to enjoin, that is to stop or prevent, the Tyler County District Attorney Lucas Babin from abusing his office and infringing Netflix constitutional rights. Babin continues to indict Netflix without probable cause for promotion of the film Cuties, a coming-of-age tale and social commentary about the negative influence of social media and the hypersexualization of young girls. Right? The problem isn't the message. The problem would be, if anything, how you go about the message, right? If you want to condemn the hypersexualization of girls, that's great. You can't necessarily do that through any means, right? There might be a lot of ways to do that, but some of those ways might be criminal. So there could be problems, potentially. Okay, as Babin is well aware, Cuties violates no law. It contains no scenes of children engaged in sexual conduct. That's probably true. It contains no lewd depictions of minors. More debatable. Indeed, other prosecutors in Texas have not only refused to take up for his ill-advised indictments, they have conceded that Cuties is not criminal, but has serious political, literary, and artistic value. That is necessarily part of the obscenity calculus, right? In order, if it has serious artistic, literary, and political value, it cannot legally be obscenity. But then again, those are at least part factually questions, right? I mean, how much value does it have and whether or not it's serious or not? And on a probable cause standard, which we all know is pretty low, right? So probable cause is pretty low as compared to preponderance of the evidence or compared to beyond reasonable doubt. So in the stage of bringing the case, is there enough to think that maybe you can get to these lines on a probable cause standard? You know? And also, obscenity is necessarily locally dependent. And my camera just froze there for a second for no particular reason. That was fun. Yeah, obscenity is necessarily locally dependent, and the Supreme Court has confirmed this. The standards that are in play when you're viewing these are local standards. So under U.S. law, as it currently exists, something can be legally obscenity in one part of the United States and not be legal obscenity in another part of the United States, because they're local standards, right? Obscenity is a locally based thing. So the same exact conduct can be obscenity or not under the current case law. So the fact that other prosecutors in other jurisdictions have declined to bring prosecution for that reason is not necessarily dispositive or even informative to some degree, because again, it's locally based. So whatever might be true of every other jurisdiction in the United States, because obscenity, when you're asking these questions, is based on the locality under U.S. law, it is possible, at least conceptually, that it could be obscenity here and not be obscenity somewhere else. That is a possibility. Okay. But this one prosecutor, out of all prosecutors in America, has indicted Netflix not just once, but 5 times. It is at least theoretically possible that it could be obscenity in this jurisdiction and nowhere else, under the state of current U.S. law when it comes to such questions. Each indictment violates the United States Constitution and comes in retaliation against Netflix exercising its First Amendment rights to freedom of speech and petition the government for redress. Enough is enough. See, this is exactly the problem, right? Whether or not it's protected First Amendment speech is exactly the problem. Is it retaliation? Well, if it's legal obscenity, it's not protected. So it's like the snake that's eating its own tail kind of thing. It's like we don't know if it's retaliation or not because they're saying obscenity, which would make it definitionally not protected. So it can't be retaliation because it wouldn't be protected speech. And a lot of that's factually based in the local community under the current case law. Okay. Babin purports to have watched CUTIES. That would be a very good thing for him to do as the prosecutor in evaluating these questions. He therefore knows the character and content of the film. As Tyler County's lead criminal lawyer, Babin should therefore know he has no legal or factual basis for any of the 5 indictments. And Babin has all but admitted he brought the newly filed indictments in retaliation for Netflix's exercise of statutory and constitutional rights to challenge the original indictment through a pretrial writ of habeas corpus. Babin's conduct makes clear that there will be no end to Babin's abuse for prosecutorial power without intervention by this court. Thus files a complaint under 42 U.S.C. 1983, a statute we know and love with so much wonderful things, right? And then we're into a 1983 analysis, and we know how that works, right? Is there a constitutional right that's being violated? And if so, is it being violated in a clearly established way? And we know what we mean by clearly established now, don't we? And as to that aspect, at least on superficial impression, it's not immediately clear. It's not immediately clear. But maybe Netflix will make the case along the way. So they seek a TRO and preliminary and permanent injunction to end the unlawful and unconstitutional campaign. Netflix does not invoke this jurisdiction lightly. Netflix recognizes that federal courts do not often entertain suits to enjoin state criminal actions. They sure don't. And acknowledges extraordinary nature of this action and remedies Netflix seeks. It is pretty extraordinary. Not for the least of reasons that the Texas courts are fully capable of analyzing these questions in the first instance. These questions of law. There's no particular reason to think that Texas's courts can't analyze these questions in the first instance. and that we need, I mean, and also, as I pointed out, the standards are necessarily local in nature. So to some degree, only the Texas courts can evaluate this because the standards are local. So on obscenity doctrine, they're local. This is a bit of a quirk of U.S. law. But, you know, that's what we're here for. We're here for the quirks, right? Many things in constitutional law are national in their nature, which is not a proposition I should have to, like, explain in great detail, right? It's not normally the case the Constitution is thought of as different from one place to another, right? Whatever the Fourth Amendment means, it probably means the same thing everywhere in the United States. You know, whatever the Second Amendment means, it probably means the same thing everywhere in the United States. Whatever freedom of religion might mean, it probably means the same thing everywhere in the United States. It would be a bit weird in First Amendment land or any other constitutional land to say, you know what, that Fourth Amendment law, that's totally different in Maine versus Florida versus Hawaii. And the freedom of religion, it's just not the same. It's not the same in South Carolina as it is in Montana. It's just different. This sounds pretty ridiculous, doesn't it? To say that, like, these things, because the Constitution, right, provides a thing that you would think would be kind of uniform. So it would be a little bit, you know, hey, that freedom of religion, that freedom to petition for redress or grievances, man, it's just different in New York City than it is in Austin, man. Totally different analysis. Does this sound like anything that makes any sense to anybody? No, of course it doesn't. If it doesn't make any sense. Welcome to obscenity law, where the rules are made up and the points don't matter. Under obscenity law, perhaps uniquely so, because I don't know of any other constitutional area that's like this, but welcome to obscenity law. By obscenity law, what is obscene is locally based. It's based on locally prevalent community standards. This has been confirmed by the U.S. Supreme Court actually somewhat recently, because this was actually an issue at the U.S. Supreme Court within, like, the last decade. I can't remember exactly when, on whether or not these standards are locally based, or whether or not, when you say community standards, are those locally based or are they somehow nationally based? And the U.S. Supreme Court said, no, they're locally based, which means, as a matter of obscenity law, the law is different, which means we're literally in a position where the First Amendment differs from jurisdiction to jurisdiction within the United States. If this sounds a little bit bizarre to you, I don't blame you. This is just the state of the law when it comes to obscenity law. I don't know that this is true anywhere else, but it's true in obscenity law. This is one of the reasons that you need lawyers because everything has so many exceptions, and you need lawyers who read a lot so they know the exceptions to the exceptions to the exceptions. And be like, well, here's one area where it differs from one county to another, and the fact that every other DA has not brought charges, and every other DA thinks they don't have probable cause, well, that doesn't necessarily preclude our analysis now, does it? Because all their opinions are, you know, and this is where we are. This is, yeah, welcome to obscenity law, man. All right, so we know who the parties are. We know jurisdiction and venue. Statement of facts. Netflix promotes Cuties, a film with serious literary, artistic, and political value. Cuties is the story of Amy, an 11-year-old immigrant caught between cultures. Her devoutly Muslim family, and Cuties, a self-named dance group of Amy's peers who have their hearts on trying out for and performing at a big dance competition in town. This is an interesting little footnote here. Although Cuties is available on Netflix customers on Netflix service, Netflix has moved for leave to file a copy of the film under seal to assure against unlawful reproduction and copying. That's pretty hilarious, right? They don't want to put it on the public docket so that we can all just steal it openly. They'll get their seal. It's just kind of funny. Like Amy, other Cuties enjoy almost no parental supervision. Unlike Amy, they also have unfettered and unmonitored access to social media and the internet, which they access through their parent-provided computers and smartphones. The unsupervised cuties wear provocative clothes and makeup intended to make them look older than they are, which we then use unsuccessfully to draw the attention of much older teenage boys using wiles their immature figures cannot sustain. The cuties also listen to mature and suggestive music to match their mature and suggestive dances, which they practice and perform in the hopes of beating much older and physically more mature dancers. Cuties uses the vast majority of its 91-minute runtime exploring and portraying various relationships. For example, fraternal, maternal, paternal, or lack thereof, and platonic, while vividly revealing to viewers the dangers and consequences of leaving children unrestrained from and at the mercy of the highly sexualized and media-driven culture in which they are now immersed. Cuties shows further the consequences of a child's unfettered consumption of sexualized media will likely lead it to more innocence lost, victimization, including self-victimization, shame, and the symbolization of degrading notions about sexuality may also follow. The dance scenes comprise roughly 7 minutes, 7%, of the 90-minute film, which sounds like quite a lot of time, actually, all things considered. There are no sexually explicit scenes involving any minors or anyone else within Cuties. Fair. While there is one scene in which a woman flashes her bare breast for a split second, the actress was 18-year-old when filmed. Yeah, that's not going to do it for obscenity. Cuties' message to viewers is timely. Concerns about hypersexualization of children, primarily girls, are heightened in Texas as the world portrayed in Cuties. These are valid, again, these are valid concerns, and they're valid bases to make a movie about, right? If you're concerned about hypersexualization of children, that is a perfectly valid thing. But you can't create hypersexualization of children along the way, or at least you can't to the point that it creates an obscenity, right? It's like, it would be like, I'm really against, I mean, just to give a really like extreme example to prove the point, right? I want to bring a movie to bear about the problem involving serial killers. In order to make this movie, I went about becoming a serial killer. There are a lot of ways to make that movie. The one I just suggested was not one of them. So, yeah, my motives might be good. My methods might leave something to be desired. Cuties was first exhibited and won awards at Sundance Film Festival in Utah. No indictments or preliminary hearings have ever resulted in Utah from any other showing of Cuties. Well, maybe Utah is more progressive. Netflix began streaming Cuties and its timely important message to its subscribers, including those in Texas, on Netflix on September the 9th of 2020. Roughly 3 weeks after Cuties launched on Netflix servers, Babin served Netflix a felony indictment for violation of Texas Penal Code, which criminalizes knowing possession, access with intent to view, or promotion of visual materials that depict the lewd exhibition of the genitals or pubic area of partially clothed or clothed child who is younger than 18 at the time the visual materials created, appeals to the prurient interest in sex, and has no serious literary, artistic, political, or scientific value. That's basically the long and short definition of, well, at least part 2 and 3 are, the long and short definition of obscenity. Appeals to the prurient interest and does not have sufficient political value. The first indictment accused Netflix of knowingly promoting visual material which depicts the lewd exhibition of the genitals or pubic area of a clothed or partially clothed child who is younger than 18 years of age at the time the visual material was created, and such material appeals to the prurient interest in sex and has no serious literary, artistic, political value, or scientific value. Babin took no issue with the first indictment with the scene where the adult woman flashes her breast. Right, because it doesn't fall within that definition because she's an adult. Moreover, although the first indictment alludes to the statute's inclusion of visual materials depicting genitals, the actual anatomical parts, as Babin knew or should have known at the time, no one's genitals are exhibited at any point, whether lewdly or otherwise. Again, under the definition, they can be clothed. They can be clothed under the definition, which may pass constitutional muster. Possibly, maybe, debatably, or not. But, like, some of this is locally driven. Now, incidentally, whether or not it has political, scientific, and literary value is not locally driven, but whether or not it offends community standards is. So some of this is local and some of this is not. And does it have serious value? Maybe. Maybe not. And even if the film itself has value, which is one proposition, that wouldn't necessarily extend to the marketing material, or vice versa, right? The marketing material would be independent of the work, at least independent enough for an independent analysis. So it at least is arguably possible that the movie itself has scientific, literary, political, or other qualifying value. But maybe Netflix possibly did something in its marketing that would go past that line, even if the underlying material does not. It's, you know, it's possible. The section does not criminalize child pornography. Right. Instead, the Texas legislature enacted the section to reach visual materials that fell outside the scope of child pornography statutes, a category of materials the Texas legislature dubbed child erotica, images portraying unclothed, partially clothed, or clothed child depicted in sexually explicit manner, indicating the child has a willingness to engage in sexual activity, whether they engage in the activity or not. By issuing the first indictment against Netflix, Babin tacitly acknowledged CUTIES does not amount to child pornography. That's just not true. That's just not true. Right? Just because a prosecutor indicts you under one section does not mean they're tacitly acknowledging that you haven't violated other sections of law. So that's a bit of a dumb argument, right? He indicted us here, not over here. That means you're tacitly admitting we did that. No. That's not how that works. In a press release Babin issued shortly after making the first indictment public, Babin mentioned nothing about the film allegedly violating any child pornography statutes. Irrelevant. To the contrary, as the first indictment, Babin claimed merely that after hearing about the movie CUTIES and watching it, he knew there was probable cause to believe they were engaged in criminality under the relevant section of the law that he's charged them with. Silence is not acceptance, right? His silence doesn't indicate anything. He says, I have probable cause under this statute. That's not an admission that he doesn't have probable cause under any other statute. It's just saying that I have probable cause under this statute. So that argument doesn't really work for me. Any reasonable lawyer who watched the film Babin claims to have done, and who conducted even a modest amount of research about the film's brief history, would have known there's no good faith belief for probable cause existing to indict Netflix for promoting the film, because there's no legal factual basis for concluding that CUTIES violates the two main elements. Now, notice what's doing here, right? And Netflix is blurring the lines, perhaps deliberately so. They're blurring the line, perhaps deliberately so. Right? There's a difference, again, between the movie being obscene and the promotion material being obscene. The promotion material is work unto itself. Like a movie poster, for example, is a work independent of the movie. Sometimes very independent of the movie, depending on the movie. Right? Sometimes a movie poster is not particularly reminiscent of the movie. For better or worse, incidentally. So sometimes the movie poster reminds you of the movie, sometimes it doesn't. Either way, the movie poster is an independent work. So it's possible, of course, for a movie poster to be obscene and not the movie, or vice versa. They're independent works. It's possible for the trailer to the movie to be obscene and not the movie. Why? Because the trailer to the movie is a different work. The movie as a whole might have serious value. The trailer, depending on how it's cut, maybe not so much. It's possible. You have to view them independently. So Netflix is arguing that Cuties has serious scientific merits or serious artistic merit, which maybe that's true. Therefore, the promotion can't be obscenity. And that's just wrong. It's legally wrong. If the promotion material is legally obscene, the fact that the underlying work is not obscene is kind of irrelevant. So Netflix is conflating it. No reasonable person who watched Cuties could conclude there's any probable cause to believe that any of Cuties' scenes violate the law. Okay. I concede your point. And therefore, what? Right? That's right. It's like, okay, I concede your point. No reasonable person who watched Cuties could conclude there's any probable cause to believe any of the scenes violate the law. Okay, I concede your point. And therefore, what about the promotion? Right? That's what we call a logic fail, right? I accept your premise and it goes nowhere. That's a logic fail. Babin has no legal or factual basis to conclude probable cause existed to assert that Cuties has no value. I accept your premise. Babin has no basis to believe Cuties doesn't meet these criteria. I concede your premise. And therefore, what? In fact, while Beeman's first indictment against Netflix was pending, his own cohorts, fellow district attorneys, conceded to Texas state judiciary that Cuties did have serious science value and could not explain Babin's decision to indict Netflix for Cuties promotion. Okay, I mean, all right, okay, the other district attorneys can explain it. Okay, and therefore, what? What's the next step in the logic sequence? Yeah. Public reaction to the first indictment was almost universally negative, as exemplified by Dallas Morning News, who described the first indictment as a document of misplaced aggression. Maybe it is in Dallas, but then remember what I said about obscenity law? After receiving service of the indictment and retaining counsel, Netflix asked to meet with Babin to discuss the case and the indictment. The meeting occurred on October the 9th at 2 o'clock in Woodville, Texas, at Babin's office. During the meeting, Netflix probed Babin and the assistant attorney as to what specifically prompted the indictment. In an effort to resolve the case quietly and without further expense to Netflix or the state, Netflix volunteered to Babins and Harley that the issue were the fleeting sight of a woman's breast. They should know the woman was over 18 and thus not a child. I'm doubting that's the issue. Netflix even offered to show Babin and Hardy proof of the fact. I'll take your word for it. I don't think that's the problem. Also, incidentally, if the woman had been under 18, that isn't necessarily dispositive, right? Just because I film and show a woman's breast, even if she's under 18, does not by itself child pornography or obscenity make. Can I film someone who's under the 18 Can I film a girl who's under the age of 18? Can I film their breasts? Can I even film them in the nude? Maybe. Just merely because they're naked? Is that child pornography? No. Not necessarily. It requires a little bit more than that. Right? We've discussed that. I mean, if the answer were different if the answer were not that, then every parent who took a photograph of their young child who was being bathed would be in violation of the law because they're under the age of 18, and that'd be ridiculous, right? So every parent who took a photograph of their baby when they're washing them in the sink or whatever would be in violation of the law. If merely taking a photograph of someone who's naked under the age of 18, if merely taking a photograph of someone under the age of 18, even if they're naked, if that alone was sufficient, well, parents everywhere would be in violation of the law. And the law's not that dumb. It's different when it's a parent. No, not according to the law, it's not. Oh, it's different when it's a parent? Oh, okay. How about every grandmother then? No, it's different when it's a grandmother. Every aunt. Where do you want to stop playing this game? You know? It's like, that's not how the law works. And it requires a little bit more. Babin and Hart expressed no need to look for such proof and conceded they had no issue with the fleeting moment. They said the gravamand, which is such a great word. I love the word gravamand. It means the gist, the heart of the matter. The gravamand of the case, the gist, the essence of the problem, the gravamand. It's such a great word. The gravamen of the first indictment was instead the suggestive way in which the younger clothed girls danced and the footage showing those dances. At that point, the conversation settled on why that kind of activity didn't meet the elements, or why, if it did, the statute couldn't survive challenge under the First Amendment. When it became clear neither side would be persuaded, the meeting ended amicably. 2 weeks later, Netflix waived its right to arraignment and entered a plea of not guilty. Between October 2020 and August 2021, virtually nothing happened in the case. No hearings were acted, the state served no requests for pretrial discovery, no experts were designated, Netflix filed no motions. In fact, even when the case was on docket for August of 2021, without any notice to Netflix and the state quietly agreed to push that initial hearing by 6 months in 2022. Oh geez, why would the court proceedings be a little bit slow? Why would it be true that not much was happening in the criminal prosecution? Why would that be true that not much was happening in the criminal prosecution? Between October of 2020 and August of 2021. Why might it be true that not much was happening in this criminal case? I can't think of any reasons the criminal case might have been somewhat paused. I can't think of anything relevant that was happening at the time that might have caused some sort of artificial slowdown in the judicial process. Whysoever was not much happening between August 2020 and 21. I'm so confused. What possible reason could there be? On October the 26th of 2021, the First District Court of Appeals in Houston struck the section as facially unconstitutional in substantially all of its applications under the First Amendment in ex parte Lowry. In reaching this holding, the court expressly invoked Babin's ill-advised prosecution under the section as justification in part for its decision. What is more, the court took this additional step of contrasting Babin's position on Netflix with the position the state took in ex parte Lowry when trying to defend the statute. The state could not explain another county's decision to prosecute and believed the Netflix movie had political, literary, and artistic value. Well, I guess this goes to show exactly what are we arguing over is very important. Are we indicting based on the movie? Are we indicting based on the promotion of the movie? What exactly is the nature of these indictments? you know, these, you know, Netflix emailed Babin a copy of the Lowry decision the day it came down, reminding Babin that he has an obligation to enforce state laws extend only to constitutional laws, and under ex parte Lowry is not one of them. This decision from this court, the First District Court of Appeals in Houston, my first question is he within the First District Court of Appeals? That'd be my first question. Because then, you know, that would go to whether or not he's bound by that decision or not, in any sense. Netflix then asked Babin to dismiss all charges against Netflix so that Netflix could avoid having to file a pretrial habeas and various pretrial motions very soon to ensure that at least pretrial habeas was decided well in advance of the initial hearing. They refused to dismiss until it served his purpose later. Unable to persuade Babin to follow the law, Netflix filed its petition for a pretrial writ of habeas, seeking dismissal of all charges on the grounds that it's facially unconstitutional under several constitutional provisions. Under Texas law, Netflix could pursue a constitutional challenge to the statute at issue through a pretrial habeas, which includes an immediate right of appeal, only if Netflix challenged the statute on its face, as did the successful petitioner in Lowry. Okay. In its petition, Netflix established that it was entitled to immediate pretrial relief on multiple grounds. The visual materials at issue were not child pornography, fair, and thus were subject to typical First Amendment standards and thus presumptively entitled to protection, not clear. The material elements were hopelessly indeterminate. They deprived ordinary citizens of adequate notice, gave undue discretion to the state's prosecutors, and thus unduly chilled speech in violation of the 5th and 14th Amendments. No, I don't think so, because except for maybe some particular wording, and if they get into the particulars of the wording, so be it. But most of the wording in this is kind of well established by law. So like some of it might seem somewhat vague, but it's like pretty rock solid as far as it goes, right? It's like the idea that it has to appeal to the prurient interest and it, you know, has to lack sufficient merit. I mean, that comes from U.S. Supreme Court case law. I can't name the U.S. Supreme Court case off the top of my head, and the fact that I can't name it off the top of my head is a little bit frustrating because I like to flex. You guys know how much I like flexing, right? I do it all the time. How much right now do I want to remember the name of the case that established all that? Because then I could flex big brain. But maybe if I keep talking, the name of the case will come to mind. Is it Jones? No, that doesn't sound right. Damn it. Pressing on. In making these arguments, especially about the issues related to the section, Netflix showed more than the section was unconstitutional, and Netflix was entitled to immediate dismissal. Netflix arguments expand something even more foundational, that Babin had never had probable cause to seek or pursue a first indictment in the first instance, and no hope of prevailing in the case, even setting aside the profound constitutional issues. After filing and later amending its provisions, petition, Netflix requested a hearing date from the state trial court. At the district court's request, Netflix filed a letter making a formal request for hearing, which then prompted the district court's offer to the parties for a hearing. Although Netflix accepted the date, Babin objected and insisted on a March date instead. Babin's only stated reason for refusing the January 4th date was his misreading of a Texas statute that requires 45 days notice to the Texas Attorney General before a trial court may enter final judgment invalidating a state statute on constitutional grounds. A statute precluding entry of final judgment with less than 45 days does not preclude a trial court from having a hearing on less than 45 days notice. Fair enough. Fair enough. Swole flex law. That's right, man. You gotta swole flex that stuff. Miller? That sounds right. Miller. Yeah, Jonah, that sounds right. Miller sounds right. Yeah, Miller versus California. That sounds right, Jonah. Jonah wins the cookie. for remembering it, the name of the case. We're finding it. Miller versus California. That sounds right. Yeah, so a lot of that language comes straight out of Miller. So I'm like, yeah, there might be some very specific problems in some of the language somewhere, but like the basic principles come straight out of Miller. Good job. Good job to Jonah for finding the case first. Jonah wins a cookie. I'm Jonah's husband. Her Google stays logged on here. Well, Jonah's husband, it's Jonah's account, so Jonah gets credit. So congratulations to your wife for being so smart. Good times. In fact, the date the clerk offered, January 1st, was 43 days after the date the Attorney General received notice, meaning that even accepting Babin's misapplication of the notice, trial court could have reheard the petition on January 4th and then ruled Netflix's favor just 3 days later, being consistent with the statute. Nevertheless, rather than trying to force a hearing on scheduled issue in a criminal case, they agreed to the March 3rd sitting. Babin's real purpose for seeking to delay the hearing petition, and despite Texas Code of Criminal Procedure's clear directive to issue such relief without delay, was purposeful effort to deprive Netflix of its day in court and the irreversible and favorable damage that section is facially unconstitutional and chill. With Netflix's habeas petition set for hearing on the 3rd, Rabin used the next 90 days to convene a secret grand jury and seek and obtain in those grand jury proceedings without probable cause. Well, the grand jury returned it, so, there's that. 4 new indictments against Netflix under the statute that had no applicability to CUTIES, but Babin knew Netflix could not challenge in habeas proceedings because, as Netflix had conceded in its habeas petition, that statute was facially constitutional. So he's changing his theory of the case. Did he drop the old indictment? So if he dropped the old indictment and he came up with a new theory of the case, and Netflix said that that's constitutional on its face, and you can only challenge if it's facially unconstitutional, then technically he gave you all the relief that you were entitled to, because the Court of Appeals couldn't have directed him not to indict under a different statute. They could have said that this indictment was wrong, but they couldn't have directed him as to other things. I don't think so. Yeah. Yeah, no bourbon today. I've got this wonderful little peach flavored tea. It's tea-tastic. It's good to stay hydrated. Also, do you think I look pretty? I got new facial products so that I will look even prettier. Do I look pretty? Please love me. Babin's plan was then to hold the indictments until the literal eve of the hearing on Netflix's habeas petition, and then announce the new indictments as decision to unilaterally dismiss the first indictment, albeit without prejudice, and thus ensure Netflix's obtain no relief, while Netflix remains indictment under this other statute. Welcome back, Monotone Daddy. Juicy says, welcome back, Monotone Daddy. I'm not sure 100% how to take that comment. Thanks, I guess. I could be less monotone. Hey guys, this is we could do my best DJ night voice, DJ radio voice. Hey guys, hello everyone, this is DJ Uncivil Law, here with your law-related needs all night long, and traffic on the hour, every hour. in the uncivil law community. Let's do a poll. I don't know why I'm doing this poll. Is uncivil law, what was the phrasing? What was it? Is uncivil law a, quote, monotone daddy? Yes. And that is good. Yes. And that is bad. No. Netflix. No. Uncivil is not monotone. Let's take a poll. Good times, ma'am. Netflix, apologize. Babin's plan was then to hold indictments until the literal eve of the hearing on the habeas petition, and then announce the new indictments, and his decision to unilaterally dismiss the first indictment, and thus have no relief on the issue. The new indictments. So, is this really retaliation? This isn't really a First Amendment retaliation claim. So, I'm not really buying the retaliation, right? So the idea of retaliation is that I'm bringing charges for you exercising their rights, and I don't think that's quite right. It's like I have a weakness in my case. I'm bringing different charges to thwart the issue. I don't know if it's really retaliation. It's not like I'm bringing the charges because you're trying to exercise your rights. I'm trying to put you in jail, and I see a weakness, and so I'm going to pick a better strategy. Yeah. By March the 1st, 2020, Babin's first indictment had been pending for more than 500 days. CUTIES content never changed during that time. Well, that would be hard. It's a movie. It's work done. Yet Babin made no effort prior to that time to amend the first indictment or issue new ones. Well, fair enough, but you exposed a weakness in his case, and so, you know, he went and looked for a better theory. Babin's decided to convene a grand jury after receiving the petition and arguments exposing not only the serious constitutional issues, but also Babin's lack of probable cause for indicting Netflix under that statute. But the court would be unlikely to get to that issue, right? They wouldn't get to the issue of probable cause. If you're getting there because of facial unconstitutionality, that's the basis of the court's decision, not probable cause. So, like, they wouldn't really be ruling on that issue. So I don't think it's quite right. Alpha says, having actually been an actual on-the-air DJ at one time, you could pull it off. Thank you. I appreciate the ego boost. Thank you. I need your love. I need your love. Like so many lawyers, I'm desperate to have my ego stroked constantly. Right? It's like I need to be reaffirmed and told I have value constantly. Yeah, I made a note of this one time that I don't think this is unique for the legal profession. There might be other professions where this is true, where you have this really strong mix of simultaneously believing that you're God's gift and you are just the greatest thing in the history of time, and also crippling self-doubt. It's like, so lawyers have that trait of having both those things, of like having this humongous ego where think that their word is supreme and think that their word is, you know, the all be all, and that no one can reach up to them, and also crippling self-doubt and feelings of worthlessness. I feel like this binary thing is a notable legal trait among whatever it might be said for other professions. Yeah. So I need to constantly be told how great I am. Lawyers are narcissists. They could also be narcissists. That's also a possibility. It could be a narcissism thing. It could also be a narcissism thing. That's fair. Babbitt also wanted to, until March the 1st, more than 120 days after Netflix originally requested, dismissed in light of this thing, and only after Netflix had spent considerable time, effort, and money preparing for the hearing. Well, Netflix is rich, so, you know. And traveling to the hearing to tell Netflix it would be dismissing the first indictment the next day. Imposter syndrome with a side of narcissism. This is good stuff. Cult Warrior says it's all over medicine. You're not alone. I believe that. I believe that I believe it's the thing in medicine too. Like these high performing professions where it's like you have this ego of God and also crippling self doubt. I believe it's a medical thing too. I believe that. I buy that. Faced with new charges it could not challenge through the pretrial habeas relief and lacking any pending charges on the statute it challenged, Netflix had no choice but to dismiss its habeas action and thus abandon all the additional rights the petition afforded Netflix, including immediate right of appeal and immediate removal of the chill. Well, it wouldn't have really done that, right? All the hearing could have theoretically done is ruled that their indictment under that statute was unconstitutional, right? So I don't quite think Netflix is right here, because I don't think it would have ended the chill. Their best possible result was that it would be ruled facially unconstitutional, which does nothing for this other statute, which Netflix themselves has already conceded is facially constitutional. So it doesn't quite work. Stephanie helped me pick up products for my facial regimen today. She helped me pick out things so I would be prettier. Yeah, she got me all kinds of products, and I don't know what half of them are or why I'm supposed to use them or when. So she told me about some of the products I bought, and I used some of the products in preparation for this. So I used some of the products, and I also shaved, by the way, in case I'm sure many of you noticed. It's been a while since I've actually properly shaved. So I shaved and I used some of the products, and then I got like 6 other products, and I'm not quite sure what they're for, but Stephanie's going to help me so that I will be pretty and beautiful and all the things. So Stephanie helped me as I was in the beauty store being like, okay, so what am I supposed to get? And she's like, get this thing. I'm like, I didn't really say to her, but I'm sure she knew. It's like, I don't know what any of these things are, but I'll just get the thing. And I went in, by the way, the reason I went in was to get new facial powder because the powder I have was running out. So I went to get new powder. So I put the new powder on my face, by the way, so hopefully its anti-shine qualities are just lovely. And Stephanie called me. I'm like, and she's like, where are you? I'm at the beauty store to get new powder. Would you like me to help you get a whole facial regimen? Yes, please. 15 products later, man. But Stephanie's great. She helps me with these things so that I can continue to add value to the channel. And all the Stephanie haters out there need to stop because she's awesome. Stop with the Stephanie hating. She's great. She helped me select some of the channel. She helped me select the story we did earlier today, by the way, on the school thing. She helped reference that story. She's good for many things, including story selection. Let's get back to the story. Man, I'm in a mood today. I'll tell you the story. It's so off point, but whatever. It's my day, right? So today I went out for lunch and I went to this taco place, this Taco Cena place or whatever, and I was in this like little strip mall, and in the strip mall there was a bakery of some kind, right? So I was like, as long as I'm here, let me go into the bakery and just see what's here, right? So I walk in the bakery, I'm like, hello, and they're like, hello. It's like, can we help you? It's like, yeah, I just happened to be, in this strip mall thing and thought I'd come in. It's like, well, we don't really have anything here. It's all made to order. The only thing we have are some cupcakes. I'm like, okay, I'll take some cupcakes. So I got like a half dozen cupcakes. And while I was waiting for them to get the cupcakes from the back room, It says, I said, so you do custom cakes? They're like, yes, we do custom cakes. I'm like, okay, I think I like a custom cake. I like a custom cake built around my hatred of everybody. And could you build me a cake that expresses my hatred of like all human beings and my, maybe it could be like green with the unbridled hatred of humanity, and maybe some black. And could you make me a cake that expresses the theme of Schadenfreude? And it was a very interesting conversation. Let me just say, I think it might have been the first time ever they were ever asked anything close to that, and I was having a great time. That was my day. Oh. Between the date of the first indictment under the law and the date Netflix filed its habeas petition, Babin had more than 400 days to convene his grand jury and seek these new indictments. Babin nonetheless waited until well after Netflix petitioned the court for redress of these new challenges. Despite previously failing to include any mention of the first indictment on the scene where an adult actress flashed her breast, that is definitely not the issue, I'm sure. And despite previously telling Netflix the first indictment was not issued as a result of that scene, and despite refusing Netflix offer to show the actress in the scene was in fact an adult, which isn't as positive as we pointed out, one of Babin's new indictments is based on the facts that they knew or should have known were manifestly untrue. Jane Dock, a white female with red hair, portraying the role of a dancer in the dance troupe, named in the picture CUTIES as Sweaty Swag, engaged in lewd exhibition of a female breast below the top of the areola, said Jane Doe having been a child who was then and there younger than 18. Well, yeah, that might be a thing where they're just wrong on the thing. Yeah. Someone said great show. Thank you. I appreciate it. Let's see. The other three new indictments Babin obtained against Netflix under the relevant law also hinge on a change that has no basis in law, that Netflix intentionally and knowingly promoted a performance, CUTIES, that included sexual conduct by the three members. Okay. Neither Babin nor the grand jury provides Netflix any notice in these indictments as to what sexual conduct they actually observe, because they can't. Which should make a motion to dismiss really easy, incidentally, for the trial court. Like, if this is true, like, a motion to dismiss should be easy. So we don't really need, again, like, the fact the federal court to intervene is unlikely. And, you know, it's something where, you know, you just wouldn't expect it. So, yeah. Let's see, what was I doing? Okay. Sexual conduct, as defined in the law, means sexual contact, actual or simulated intercourse, deviates sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, or lewd execution of the genitals, the anus, or any portion of the female breast below the top of the areola. There's not a single scene that depicts any of these explicit acts or where a child exhibits any of these things. To apply as broadly as Babin apparently does, will criminalize not only CUTIES, but a vast swath of protected speech, making the statute unconstitutional as applied to Netflix and CUTIES, and make felons out of millions of Texans, every purchase who has streamed CUTIES since its arrival on Netflix, every person who has promoted or advertised the film, such as by posting a positive film review on a popular media site or media. See, not necessarily. It depends what the basis of these indictments are. Right? Is it based on the movie, or is it based on the promotion of the movie? In which case, you could distinguish against other people promoting the movie. What exactly are they indicting them for? Are they indicting them for the movie, or are they indicting them for the promotion of the movie? In which case, what are the promotional materials that they're going over? Or maybe Netflix doesn't know. And that's the problem. But, or maybe Netflix is hiding the ball, and they do know, and they're not making it particularly clear. So it's like Netflix is, I don't know, man. By the way, just for the sake of disclaimer, to the fine people at YouTube, as always, by reading this, I am merely reading actual cases that are ongoing on our legal system. I am not actually encouraging anyone to engage in any particular kind of behavior. I'm not encouraging anyone to do anything. I am having a legal analysis in which I am describing some things that may or may not be legal. And just because they may be legal doesn't necessarily mean people should be engaging in them. And I'm most decidedly not asking or encouraging anyone to engage in any illegal behavior because, among other things, that will be unethical for me as a lawyer. Please do not break the law in any sense. This message is required by YouTube. I should just get a disclaimer that I put up on screen. That's what I need to do. Just get a disclaimer. Change my intro screen and put a disclaimer up there or something, so I don't have to keep saying it. What a lame reality I live in. Netflix was ready to resolve. Also, I definitely am not encouraging anyone to buy any cryptocurrency. That is definitely not a thing. Netflix was ready to resolve Babin's original and baseless first indictment in state court, but Babin, through bad faith and retaliation action, stripped Netflix of its ability to obtain relief against the first indictment, blah, blah, blah. Now seeks to vindicate its constitutional rights in a federal forum because the nature of it, coupled with bad faith. Yeah, this doesn't feel like this is going to work. Okay, count one. Violation of their rights under 1983. Acted under color of state law, yes. In violation of Netflix Fifth Amendment rights. Fifth Amendment rights? Are you sure you don't mean first? Is that a typo? Do you mean fifth? Which Fifth Amendment right did you have in mind? Are you going due process? But that would be a 14th Amendment right. I'm confused. Anyways, despite the fact that the visual materials that fall within the section scope are subject to Miller's established test, there's that case Miller that I couldn't remember. And yes, that is exactly right. Like, this is exactly the problem, right? Despite the fact that visual materials that fall within it are subject to Miller, it fails to incorporate all of Miller's elements. Does it though? I mean, it's been a long time since I read Miller, but it sounds roughly correct. And because the section lacks all of Miller's elements, the only way to save the statute is to rewrite it by judicial fiat, which itself is impermissible. Moreover, pled within the section's unique... Well, what elements do you think are missing? Do you want to make that clear? That'd be great. Moreover, placed within this unique context, several material elements of the statute, its mere knowing standard for culpability, its undefined use of lewd exhibition, and seemingly futile or incoherent use of Miller's appeals to the pure interest in sex tests, renders statutes hopelessly indiscriminate, invites arbitrary and unconstitutional exercise of prosecutorial power, and thus chill speech. I'm not sure I buy any of this. Like, I'm open for the possibility that this doesn't track Miller or is excluding something from Miller. But as they pointed out, like, a lot of this language comes from Miller. And the things they're complaining about right now come from Miller. I mean, it's been a long time since I read Miller, but this all sounds right. It's like, you know, I've got that piece of my knowledge somewhere in the back of my head. The fact that Babin dismissed the first indictment and charges under the section does not deprive Netflix of the ability to challenge the statute's validity in court. In this court, I think it kind of does. Babin already charged Netflix under the statute, required Netflix to endure prosecution on the statute for more than 500 days before unilaterally dismissing the indictment to avoid having to both defend his indictment and the statute in a losing battle. As to that statute, he might have lost, but he found a different statute. So again, it's like, yeah, it doesn't quite work because Netflix might have won, but it wouldn't have really read on what he's doing now, I don't think. So it doesn't quite work. Babin already challenged Netflix under statute, requiring Netflix to endure by expressly seeking dismissal of the first indictment without prejudice and reassuring the basis. Babin has reserved his right to re-indict under the section in the future. The bad faith effort to avoid the challenge, Netflix therefore, okay. So I don't like this cause of action just because they say that it doesn't include all the elements of Miller. But unless I misread it, does anyone remember at any point? Does anyone remember at any point them saying what elements of Miller were missing? Does anyone remember them saying, "Hey, by the way, that case Miller, it had this language, and the statute doesn't have this language, and so that's a defect"? I don't remember that argument. Does anyone remember that argument? Because I don't. They just say, okay, it doesn't incorporate all the language of Miller. Okay, what language from Miller is excluded? Would you like to tell me that? That'd be great. And then I can decide, like, among other things, whether or not that matters. You know, because it might not necessarily matter because it doesn't necessarily need to be a word for word proposition, right? And we've seen this in example for other things. For example, the four-part standard for preliminary injunctions, for example. It's the same four-part test by every court. Courts worded a little bit differently, but it's the same four-part test, right? So it doesn't have to be word perfect. It's like, okay, it's just the same exact concept expressed in slightly different language that ultimately is immaterial. So maybe it's the case it doesn't track Miller, but maybe it doesn't matter, or maybe it does, but I don't know what language you think is missing from Miller, or why you think that matters, or I mean, I don't quite have it. It's a little vague. It's like you don't quite have what you need. Moving back. Count 2. Forgot to. Little typo there. Fully incorporates the things, paragraphs 1 through XX. We all know what you mean. It's fine, but it's a little funny. Babin acted under color of law in violation of Netflix First Amendment rights when he indicted and prosecuted under the section because it's impermissible content and viewpoint-based restriction that's not narrowly tailored. If it's obscenity, you're there. If it's obscenity, you're there. Which goes back to Miller. It makes me wonder what test is missing from Miller. Because it criminalizes activity not based only on the content of visual material, but also the viewpoints when promoting such material. Does it, though? Does it criminalize based on the viewpoints? I don't think it does. The fact they dismissed the first indictment charges under the statute does not bribe the ability to challenge. Seeking dismissal without prejudice. Okay, count 3, another little typo from our friends at Netflix. Acted in color of state law. Applying the section's prohibitions against sexual performance of a child to CUTIES violates the First Amendment because in stretching the definition of sexual conduct to cover the conduct shown in CUTIES, Babin stretches the term beyond their constitutional bounds and criminalizes otherwise protected speech, a fact that counterparts have expressly recognized in other cases. This is true even of Babin's indictment in the case. As explained here, because Babin knew the actress was an adult, as to that much I'll give you. As to that much I'll give you. If they're trying to indict you over that, I'll give you that Netflix all day long and twice on Sunday. Like, yeah, and even if it were a child, that alone would not be enough. Like, for reasons we discussed. Although they're actively pending in state court, the bad faith, his utter knowing and lack of probable cause, purposeful use of discretion, file and dismiss charges, strip Netflix of right to seek redress, permits and justifies this court not only to maintain jurisdiction over the claims, but also to enjoin them from pursuing it. Another little typo from Netflix. That's their third one. Acted under color of state law in violation of the First Amendment rights when it retaliated. I'm not sure about the retaliation argument. He waited 500 days to bring new and frivolous charges and dismiss the original charges. And for retaliation, not clear on its face. And so we want a prayer for relief. So, yeah, I'm a little bit dubious of this. I'm a little bit dubious on this on a whole bunch of levels, right? I'm dubious on this on a whole bunch of levels because, as they know, it's very extraordinary to get a federal court to stop an ongoing state-level criminal prosecution. That's, like, not really a thing. You'd have to have it be really blatantly obvious, right? So under 1983, I don't think you're there. Because we've discussed 1983 and its standards, for better or worse. And we know how hard it is to get to 1983, which is like the basis of their thing. Right? It needs to be clearly established. It needs to be a violation of the Constitution, which we're not quite sure. And it needs to be clearly established, which we're even less sure about. So, yeah, I think it's premature for the federal court to intervene. It sounds, if what Netflix is saying is true, it sounds like some of these counts can be dismissed by the state court. There's no reason to think they won't dismiss them if what they're saying is true. If what Babin is complaining about is the actual movie itself, if that's the basis of his complaint, the movie, then he has problems. He has problems out the ass. Right? If his basis is the movie, he's done. So it depends a lot on what these indictments are over. So what do we mean exactly by promotion of the movie is my question for this. Because if we're trying to say, oh, merely by promoting, if we're not arguing something specific about the promotion itself, okay? If we're just simply saying promoting the movie in and of itself, right? By its own terms. Yeah, Netflix is right. And I'd have no problem as a judge throwing it out, right? I mean, obscenity is a pretty hard trigger to pull. And to say it has no merit under like the normal tests, like, yeah, it's like, no. So if the basis of the complaint is the actual movie, then Netflix is right. If the basis of the complaint is then the promotional materials for the movie, then I need to go see those. And some of those materials might on their own be closer. But yeah, it depends a little bit about specifically what's going on. But for me, this whole thing feels a little bit thin. I don't particularly like not being told what the problem is in Miller. Because I don't like that, right? I don't mind an attorney saying like a case doesn't read on something. I think I made a point of this when with Salter Brown doing it too, when we're doing without the crystal ball stuff, where they said, when one of them said like whatever thing, it's like, oh, that case doesn't stand for that proposition. And then I got really salty because they didn't do what I think is the necessary next step. Tell me what you think it stands for. You want to say it doesn't stand for that, fine. Give me an alternative, right? You can't just say nuh-uh. You know, nuh-uh doesn't do a lot for me personally as a lawyer. No, that's not what it means. Well, what do you think it means? Nuh-uh. Could you be a little bit more specific than nuh-uh? Nuh-uh. Not really helpful, right? So, same thing here with Netflix with the Miller. That's not what Miller says. You don't have all the elements of Miller. Which are... What? That's not Miller. Nuh-uh. It's like, that's not really working for me. I'm gonna need you to tell me what elements you think are missing and why those elements matter. That'd be great. That'd be super helpful. So that doesn't really help me very much at all. As a federal judge, I don't think, based on this, I'd be inclined to grant this, just because, again, it's extraordinary. It feels like the state level courts can do it. It feels very premature. It feels like one of those abstention moments for me as a federal judge, to be like, I don't know about this. It's like there's a lot here that's turning on facts, of which the state level courts are presumably equipped to review, and stuff like this. And to the extent that you think that they're playing games, there's not enough here by the prosecutor to really quite do it for me as a federal judge. If I were doing it as a state level judge, maybe. If I were looking at this like as the Texas Supreme Court or a court of appeals in Texas, I'd be asking slightly different questions. But as a federal judge, I'm like, I'm not sure. There's a role for me to intervene, on federalism grounds and stuff like that. So, yeah, I'm not 100% sold on all that. The results of our poll. The results of our poll in terms of whether or not uncivil law is monotone daddy. No, uncivil law is not monotone at 47%. Yes, and that's good at 45%. And yes, and that's bad at 7%. So about evenly split between people who think, yes, uncivil law is monotone, and no, he's not monotone. But most of you think it's good, so I guess that's a good thing too. Yeah. So all that stuff. So I hope all those things are good, and I hope you enjoyed this stream. And we'll follow it up. We'll follow it up with the attorney's response, and if there's a decision from the court, we'll follow that up too. But you'll see where it goes. Where's the overall jurisdiction? I don't understand the question. What do you mean? The overall jurisdiction with respect to the obscenity jurisdiction? Like, what's the relevant jurisdiction? It's not really specifically defined by the relevant law. It's just whatever the local community is. What's the local community? Great question. What's your next one? I haven't joined locals as Salty Crackers said it's $5 a comment, and you're not monotone. I don't think it's $5 a comment. Stephanie says cover another story. Okay. Let's see what else we got. Monotone is not the same thing as monotonous. That's true. Is it Texas or federal? What Texas or federal? The thing we just read is a federal thing to try to enjoin the Texas state prosecution. I think Stephanie sent me something else. Let's see. A 13-year-old was driving a truck that struck a van in Texas, killing 9. Whoa. That's not good at all.
And we're following several breaking news stories.
I don't need your video. I just need the article so I can cover it. Thank you. Great. Hate when they do that stuff. All right, let's cover this other article that Stephanie sent over. Due to Halderson sentencing and the idiot attempting to skip it, Stephanie, could you do me a favor and while I'm covering this and send me an article describing that or the motion describing it, because I don't have that. If you could send me an article describing it or whatever, or the actual motion or the judge's order or whatever as a basis to discuss it, I'll discuss it after this. That'll be fine. All right. So NTSB says a 13-year-old was driving a truck that struck a van in West Texas, killing 9. 6 New Mexico college students were killed in the crash along with their golf coach. That's pretty horrific. A 13-year-old was driving the pickup truck that struck a van in West Texas in a fiery collision this week. This is from March 17th, 2020. So that's today. So this week, I'm not sure exactly what that means, but presumably in the last 7 days, according to the NTSB. The NTSB vice chairman said the truck's front tire, which was a spare, also blew out before the impact. Yeah, you're not really supposed to drive on a spare for any length of time, as I'm sure people know, or not. And you're not supposed to drive when you're 13. The Texas Department of Public Safety Sergeant Victor Taylor said a 13-year-old driving would be breaking the law. A person must be 14 in Texas to start taking classroom courses for a learner's permit. That can't possibly be true, can it? You have to be 14 to even take a class? That seems odd. That can't be right. If I want to have an 8-year-old take a classroom course on driving safety, I can't see how that's illegal, but okay. You have to be 14 apparently to do this, and 15-year-olds to receive a professional license to drive with an instructor or licensed adult. I'm not sure what a learner's license is. The pickup truck crossed the opposite lane on a darkened 2-lane highway before colliding head-on with a van, killing the boy, a 38-year-old man traveling with him, who presumably was his father or something, and probably should be driving, 6 New Mexico college students, and a golf coach. The University of Southwest students, including one from Portugal and one from Mexico, and the coach were returning from a golf tournament when the crash happened Tuesday night. So this is 2 days ago. 2 Canadian students were hospitalized in critical conditions. The deceased students have been identified as the following: Tyler James, 26, who's the head coach at 26. Mauricio Sanchez from Mexico, 19. Travis Garcia, 19, from Pleasanton, Texas. Jackson Zinn, 22, from Westminster, Colorado. Carissa Rains, 21, from Fort Stockton, Texas. Lacey Stone, 18, from Nonca, Texas. And Diego Souza, 18, from Portugal. The NTSB sent an investigative team to the crash site in Texas, about 30 miles east of the New Mexico state line. Stephanie, is that odd? I mean, you would know. Is that odd for the NTSB? Is it because of the number of people killed? The NTSB? I mean, I would imagine the NTSB does not investigate most collisions. What about this? Just out of raw curiosity, do you think gets the NTSB involved? Stephanie wouldn't be in a better position to know, by the way. That's why I asked Stephanie. She would have more knowledge of this. So maybe she can help me out on why the NTSB is investigating this particular thing. Is it because 9 people died? Is it because I don't know. Apparently a learner's license is a learner's permit, so you have to be 14 for the permit. Okay, fair enough. The golf team was traveling in a 2017 Ford Transit van that was towing a box trailer when it collided with the truck, and both vehicles burst into flames, according to the NTSB. He said the vehicles collided on a 2-lane asphalt highway when the speed limit is 75 miles an hour, though investigators have not determined how fast either vehicle was traveling. The University of the Southwest is a private Christian college located in Hobbs, New Mexico, near the state's border with Texas. A memorial was set up on Wednesday at a golf course near the campus where the team practices. There were flowers, golf balls, and a handmade sign with a cross and the initials USW. It's the very least we could do for the players and, of course, Coach James. The kids were great kids, and they were great community members. The New Mexico governor said on Facebook that they're deeply saddened by the loss of life. This is a terrible accident. As we await official information, my prayers are with the community and loved ones. We grieve with the loved ones of individuals whose lives were horribly taken too soon. Well, that's a bummer. That's a bummer. 9 people are dead, man. That sucks. That sucks. And 2 people were in critical condition, man. Because a 13-year-old was driving a truck with a spare tire that blew out and lost control and resulted in a head-on collision on a road with a 75-mile-an-hour speed limit, which means the accident probably took place at roughly 70 miles an hour, I guess. And 9 people are dead. Man. And they're all, I mean, except for the 38-year-old who's the oldest of the group. I don't want to hear your...
First new information about that horrible wreck in West.
Damn it.
Turns out a 13
Where's the audio coming from?
pickup truck that hit us.
Goddamn auto-playing audio. Okay. Let's take a look at this other thing about this. So, yeah, Jackass was sentenced to life without parole, and Chandler Halderson for the killing and the mutilating of the parents. So that would be good. Let's take a look at this. Is this another auto-playing thing? I don't need auto-playing in my life, man. They're on a quest to ruin my life and shatter my calm. That's what's happening. They're trying to shatter my calm. Why are they trying to shatter my calm, Stephanie? Why are they trying to shatter my calm? Let's see. 317. Okay. Judgment of conviction. Written statement stands hearing. I can't find what I need to right now in the docket, so I'll skip that for the minute. And I will go to this article relating to him trying to skip out on his own sentencing hearing. I will print off this one too. All right. Let's discuss this real fast. Chandler Halderson sentenced to life without the possibility of parole. I believe today was his birthday too. I think today was his 24th birthday, if memory serves correctly. I wonder if I can confirm that. But I think today was his birthday. Chandler Halderson. Birthday. July 1st. No. Well, what's his day of birth? I think today might have been his birthday. I'm not sure. Anyways, doesn't matter. He's either 23 or 24. He's either 23 or 24. chopped up his parents after murdering them, distributing their bodies around. Chandler Halverson, given life without the possibility of parole. Sorry about the font size being relatively small. I'll read it to you. 24-year-old Dane County man convicted of killing his parents last summer and chopping up the bodies and spreading them around was sentenced to life in prison without possibility of parole. Chandler Halverson will receive maximum penalties for the other charges, which will be conserved concurrently. They received 3 years for 2 counts of false imprisonment in a kidnapping, 7 years and 6 months for 2 counts of mutilating a corpse, and 7 years 6 months for 2 counts of hiding a corpse. They say concurrently. I thought it was consecutively, though. Halverson has 20 days to file for an appeal, which defendant said he would in his first time speaking in the trial process. Yeah, by the way, I watched part of the sentencing hearing. I watched kind of the end of it. Just as the actual sentence is being given down by the judge. So I skipped, the preliminaries and just waited until the end. And so at the very end, they say, after the prosecution gives its stuff and the defense gives its stuff, the judge makes a point of saying, the defendant has a right to address this court if he wants. And I understand from the motions that were made or the papers that were filed that the defense has indicated that he will not take advantage of that opportunity, but I'm still going to confirm that that's his intention right now, which is, of course, the law, right? He has the right to address the court or not, and that has to be his decision. And so his attorneys say, well, he's not going to do it. And so the judge says, well, I just want to make note that, it's his decision, and I'm asking whether or not he wants to. And apparently he is going to. So he decides to talk to the court during his sentencing. So he pulls off his mask, and what he says, and I'm going to paraphrase it. He says, if there are any attorneys out there who want to take up my case, please let me know. And I just want to let people know that I do actually have feelings. It was just that I was advised not to show those feelings while my case was ongoing. And that was about all he had to say. It was like 2 sentences. And it's like, yeah, no one's going to take up your appeal because there are no grounds to appeal. You're done. You're just done. Enjoy being in prison forever. The prosecutor, Andrea Raymond, started by describing the nature of the defendant, saying the 2 parents who had supported him. Bart Halverson served as a Boy Scout den leader and attended his son's swim meets. Raymond argued the only real tragedy Chandler Halverson ever experienced was the loss of his maternal grandparents as a child, and the only potential criticism they could give him was his mother may have doted on him too much. The more and more I learned about this Chandler guy, the less I like him. The prosecutor had also stated that during all jail calls and messages with detectives prosecutors listened to, there was never a moment where Chandler had mourned his parents' death. The first victim impact statement was from the fiancée of Chandler Halverson's brother, Mitchell. She said that she had lost her future mother and father-in-law, and she would miss them every day. She also stated both her and her fiancé would be uncomfortable if the court allowed them to have Chandler to have the possibility of parole. Chandler Halverson's grandmother penned the next victim statement read by prosecutors. I love him even though what he did was horrific, the statement from the grandmother said, followed that she would hope that he would find a trade or craft while in prison. She also stated that his parents would not want him to be incarcerated for life. Krista Halverson's best friend of 38 years, Jane Higgendorf, was the next person who had a victim impact statement. Higgendorf had testified during the trial as well. She described Krista as having a lightheartedness about her. When she walked in the room, she made people happier. Being a mom was her purpose in life, said Higgendorf. Deputy District Attorney William Brown asked the judge to sentence Chandler Halverson without the possibility of parole. He stated the court needs to consider the potential rehabilitation needs for the defendant and safety of the public. Mr. Halverson, by all accounts, chose to commit the crime of first-degree intentional homicide twice on a single day because he was caught lying about where he was working and going to school. Or perhaps just where he was going to school. Defense attorney Crystal Vera doing yeoman's work over here with the absolutely nothing. So, give a shout out give a shout out to defense attorney Crystal Vera, who has like the worst job ever, right? She's defense lawyer for this guy, and she has to defend this guy with the nothing. I mean, you know, my heart's out for you, man, right? Your client may be the absolute scum of the earth, but you're not. You're given the, I mean, God, you gotta like this, right? You're given the impossible task, man. Talk about Sisyphean, right? You're given the impossible task of, hey, try to get Chandler Halderson not guilty verdict. Also, try to make sure he doesn't go to jail forever, man. That's a rough day as an attorney. And then also try to make sure everyone doesn't hate you in the process. That's a rough day, man. That's a rough day, man. I feel for you out there. Hard out to Crystal over here, whose client sucks ass. Saying there's no statements from the defense. She said the defense was asking the judge for the possibility of parole for Chandler, emphasizing it's not a guarantee. So it's not a process that's a guarantee, Vera said. It's simply a process we're asking you for to allow the possibility of that process happening. I cannot stress that enough. I cannot stress enough how we're all asking for today is the possibility of this man to show you he's redeemable. She also argued that Chandler, who apparently now is 24, and it might have been his birthday, had a lot of growing up and adulting he's going to miss out on in that institution. When Chandler spoke for the first time, he said if any lawyers were listening, he plans to appeal his conviction. I think you're going to be hard-pressed to find a lawyer to help you, not for least of reasons that we're going to have a really tough time finding anything that's a viable cause of appeal. You see, one of the problems for attorneys is we have to make ethical arguments, right? We have to make ethical arguments. We have to find something, anything. And we're having a tough time, Chandler. We're having a tough time here. You know, not saying it's impossible. I do love a challenge, though. I love a challenge. I am masochistic enough, and maybe it says something about me as a person. I am masochistic enough that if I were being paid to do it, I'd try. Just because I do love that position of being behind the eight ball. I like that position of having to really like find something, anything to work from the nothing. And like not to say that I'd find anything that could work, but just the thrill of trying to like really rack your brain and like how do I go out there with the nothing and try to make it work? That can be very, very satisfying in its own way. So there is a part of me, I'm not gonna lie, there's a part of me that would be like, geez, you know, if I were an attorney in this jurisdiction and I'm getting paid, which he doesn't have any money, so, you know, that's a non-starter. But I'm not doing it for free, that's for damn sure. I'm not putting myself through this effort for free. But if I were getting paid, there's a part of me, it's like, you know, all right, give me the file. How can I work? How can I build something from the nothing? You know, the challenge, the thrill. Yeah, following the defense statement, judge asked if there were any positives. It was demonstrating the pride we should all feel in an area, law enforcement, for how they investigated. While I did not know the Haldersons, the judge said he knew people like them and can understand the empty space lost in their lives. This court honors your loss, Highland said. Yeah, the judge also was kind of half crying during it. Well, that's not fair. You could see he was emotional. And there was the prospect of tears in there. He was obviously distraught at the horror show of the crime. And he was upset. And he even made a point of saying that the Haldersons, like the rest of the Haldersons, like they even like recognized their loss, which was kind of a nice touch. You know, because, you know, Halderson's brother, that's a rough go, man. You know, that's got to be a rough position to be in. He explained that on top of the offenses themselves, Chandler Halderson's activities to hide the crime made them worse. Ultimately, for the safety of the public, Highland ruled he could not give Halderson a chance to receive extended supervision, which is what they call parole in this state. They call it extended supervision. Quote, I don't like telling his grandmother that I'm not able to give her the relief she's asking for out of love for her grandson. I cannot do that, the judge said. I have to, for this sentencing, ensure this is a nice little quote. This is a nice little burn from the judge. I don't know if he meant it as a burn, but it was a nice little burn moment. And he didn't say it with any satisfaction either. He said it almost sadly, because I think, distraught by the whole thing. So he didn't say it with any glee or anything, but it was such a nice little burn. The judge said, quote, "I have to, for this sentencing, ensure that the only time Mr. Halderson comes back to the community is to have the privilege of a burial that he denied his parents." The only time you get to come back to this community is for the privilege of being buried. Wow. That's a lot of burn, man. There's a lot of burn. Chandler Halderson had to be there when the Dane County Court handed down its sentence for killing both Bart and Halderson. A judge ruled. The 24-year-old had requested to skip his sentencing. State law requires he receive life sentences for 2 convictions of first-degree intentional homicide for the deaths of Bart and Krista Halderson. He will also be sentenced on 6 other charges, including each of 2 of mutilating a corpse, hiding a corpse, and providing false information. According to the court records, 3 victim impact statements were filed. Bart's father, Blake Halderson, sent a letter opening up about how his son and daughter-in-law live their lives and how it's hard being without them. So that's his grandfather. Yeah. Halderson's filed a motion asking the judge to allow Halderson not to be present at a state sentencing hearing. Ooh, I wonder if I can actually get a copy of this. That'd be cool. Get a copy of this motion. That'd be fun just to discuss. Defense attorneys cited the statute which lists age proceedings which the defendant shall be present, but noted that if a defendant refuses to come to court, sentencing may proceed. On the face of it, the attorney writing this, on the face of it, it does indicate a defendant shall be present at sentencing. However, a defendant is in custody and refuses to be brought. Sentencing may proceed and be completed if the defendant waives his right to be present. The defendant has waived his right to be present and not only consents to, but requests to be absent. In a letter from the deputy district attorney who presided on the trial, Brown argued that Halderson cannot skip a sentencing hearing and described the request as absurd. Halderson is no longer shrouded by a proverbial cloak of innocence. He's a convicted murderer, body mutilator, and liar. His request to skip his sentencing hearing is absurd and affronts the public interest and expectation of the court system. Brown continues argument summarizing a case in which the Wisconsin High Court decided a felony. Defendant in a felony must be present. The sentencing of a criminal in public and in full view of critical eye of the public and press is a vital check on our system and must not be meddled with. Defendant should be brought to the courtroom for sentencing in full view of the community and victims he so badly hurt. And apparently he conducted an interview. NBC had conducted an interview with him, which is audio only, which is kind of hilarious. Let me see if I can find a copy of this motion. It's probably in the article that she gave me. And let me see if I can find it. Hold on one second. See if we can find a copy of this motion. That'd be good.
I've never seen this.
No, no copy of the motion, unfortunately. But yeah, he attended. So he wanted to get out of attending his own sentencing hearing, which, I can't blame him. It's like, but, no, we're going to drag your ass there, whether you want to or not. So fair enough. Fair enough, All right. So is there anything more for today? I think that's a good place to end the stream. 2.5 hours in, we had a good day, right? And now I have to figure out what the rest of my facial products are for. as I get ready to, you know, make the magic happen. And that is me. So I'm going to sign off for now. If you've enjoyed the stream, please remember to like it. Please do the subscribe. Please do the YouTube things. Hit the join button. For 99 cents, you too can become an Uncivilian. Get your name on screen. It's true. You might have seen people's names scrolling on screen as we were doing this story. You're like, how can I get my name on stream? It's easy. Hit the join button that Streamlabs tells you about, or hit the link or whatever, and you become an Uncivilian, and you get cool little icons by your name, and you become an Uncivilian. So I hope you enjoyed these stories. I enjoyed these stories. We will definitely keep note of what happens in this Netflix Cuties thing, because that's kind of interesting. We'll follow it. And until then, my friends, I hope all is well. Cheers, my friends. And goodbye.